Hi, I'm Michael Santos with Prison Professors, and I really want to welcome you to our app. We hope that you will use our app and subscribe so that you can get information to help you make the best decisions, interact with your attorney more effectively, understand how every decision you're making today can have a direct influence on what you experience in the days, weeks, months, years, and decades ahead. I served 26 years in prison. You can get all of that information by visiting us at prisonprofessors.com, but through our app, I want to just provide some brief information that will help you, I hope, make better decisions. So I'm just going to scroll through this link here while I'll read some of the content, because you may want to get this information on audio rather than reading it. So let me just go ahead and read it for you, and I might give some extra commentary as I'm moving down. And this is for the pre-sentencing phase. So according to H.P. Lovecraft, an American writer, the oldest and strongest emotion of mankind is fear, and the oldest and strongest kind of fear is fear of the unknown. Well, people going into a government investigation or facing criminal charges know what I am discussing. I am Michael Santos, founder of Prison Professors. We launched our nonprofit to offer resources for justice-impacted people who want to help themselves. And getting help starts with understanding. If people don't understand the process, they lack clarity on different mitigation strategies they may engineer. Now, the best time to avoid complications from a government investigation or criminal prosecution may have been years or decades ago. But the second best time is today. Start by understanding the process. The pre-sentencing process includes many stages, which I will attempt to explain below. First, let's just talk about the investigation. Sometimes people have a hard time understanding the nature of a government investigation. Authorities may learn of some crimes in real time. For example, a law enforcement officer may watch a crime take place. That can launch an investigation. For white-collar crimes or transaction-based crimes, the investigation may begin in secret. A conspirator may get caught doing something wrong and offer information, which can begin an investigation. Officials in a financial institution may become suspicious of transactions, and to show their commitment to law-abiding behavior or good corporate citizenship, those officials may notify law enforcement, which can trigger an investigation. A whistleblower may pursue a reward by notifying law enforcement of a crime. Once authorities become aware of a potential crime, investigators start asking questions. They place people in one of three categories: a witness to an investigation. Now, a witness to the investigation may be someone with knowledge of how a business operates. Investigators may want to approach the person in secret and ask the person to keep the conversation confidential. The investigators want to understand what is going on. As subject of an investigation, when investigators suspect that a person may have some involvement in a crime, they may assess whether the person can bring value by providing detailed information about the principles of the crime. They may determine whether they want to elevate the person of interest to become a target for prosecution. And then there's a target of an investigation. When authorities have spoken with enough people and reviewed sufficient documents, they will identify the target of the investigation, the people they intend to charge. If authorities identify a person as a target of an investigation, a criminal charge will likely follow. So what are the charging instruments? Prosecutors may choose a pre-indictment proceeding and bring criminal charges through a criminal information or criminal complaint. Or they may decide to convene a grand jury. Criminal information and criminal complaints. What are they? Well, prosecutors may attempt to persuade a target to plead guilty during a pre-indictment proceeding. They will typically offer an inducement to avoid a trial. For example, prosecutors may agree to bring a charge that does not have a mandatory minimum sentence or charge a crime with a lower statutory cap. What about a grand jury indictment? Well, if the prosecutor and target do not resolve the matter earlier, prosecutors may convene a grand jury. A grand jury is a group of citizens that listens to the prosecutor present evidence. The evidence may include documents or live testimony from witnesses. Since a defense attorney is not present during grand jury proceedings, the grand jurors only hear the prosecutor's version of events. The prosecutor will ask members of the grand jury to indict the target. What about an initial appearance? If the prosecutor and defendant agree to a pre-indictment charge, the prosecutors may authorize the target to surrender to court for an initial appearance before a judge. When prosecutors bring charges through a grand jury indictment, they may choose more aggressive stances. Teams of FBI agents or other law enforcement officers may storm the person's residence or place of business to make a public arrest. They will take the person away in handcuffs, depending on the time of day. The law enforcement officers may take the person to a federal courthouse or detention center if it's too late for a judicial proceeding. Ordinarily, within 72 hours of the arrest, officers will transport the person to a courthouse for an initial appearance before a judge, or if either a district court judge or a magistrate judge. During the judicial meeting, an officer of the court will ask the defendant questions, and that pretrial officer will want to gather as much information as possible to give the judge a sense of the person's ties to the community and his trustworthiness for a bail or bond. During the initial appearance hearing, a prosecutor will recite the charge against the person and ask the judge to set a bail amount, or ask the judge to decline a bail amount and hold the person in pretrial custody. Now, a defense lawyer will advocate on behalf of the defendant. If the defendant doesn't have a lawyer, the court will appoint a lawyer, assuming the person qualifies with a lack of financial resources. The judge will ask the defendant to enter a plea. Unless there is a previously negotiated plea agreement, most defendants will plead not guilty at the initial appearance. The judge will set conditions for bail, or the judge will order the defendant into custody. And that's when discovery starts. During the pretrial proceedings, the prosecutors should present the defense team with the evidence they have gathered. It's not because they want to make the case easier, it's because they have to, under a Supreme Court ruling known as Brady that requires them to give all evidence they're going to use to the defendant. And the defense team is going to review that evidence and decide whether to proceed through a trial or negotiate a plea bargain. And there's the plea bargain. In exchange for a rapid resolution, the prosecutor may choose to offer a plea agreement. The Constitution provides every defendant with the right to a trial. Yet if the defendant loses at trial, in most cases, the defendant will face a much harsher penalty. Most people accept plea bargains to facilitate the likelihood of a lower sentence. To qualify for an even lower sentence, a defendant may agree to cooperate with authorities and help prosecutors bring cases against other people. Then there's the change of plea hearing. If the prosecutor and defendant agree to a plea bargain, the next step will be a change of plea hearing. The change of plea hearing is a relatively simple procedure. The judge recites the charges that the prosecutor brought against the defendant. Then, the judge will ask the defendant a series of questions. Those questions will help the judge ascertain whether the defendant is entering the plea knowingly and voluntarily. If the defendant meanders or fails to convince the judge that he is guilty, the judge may reject the plea bargain. Defendants often agree to plead guilty to a charge even though the defendant doesn't honestly believe he is guilty. Yet pleading guilty is the only way for the defendant to minimize exposure to the higher risk levels for himself or for others. To reap the benefits of a plea agreement, the defendant must convince a judge that he understands the charge and that he enters the guilty plea voluntarily and with full knowledge that the plea agreement does not bind the judge. The rules of criminal procedure include a provision for a conditional plea agreement under 11C1C. Now, some courts accept 11C1C pleas, others do not. But this specific type of plea agreement allows the defendant and the prosecutor to agree on an appropriate sentencing cap. The judge retains the discretion to accept or reject the plea agreement, but if the judge agrees with the 11C1C plea agreement, the judge also agrees with the sentencing deal. After the plea comes the pre-sentence investigation. See, once there is a finding of guilt by plea or judicial finding, the judge will order the U.S. Probation Department to conduct a pre-sentence investigation. A probation officer will get the prosecutor's version of events, and the probation officer will attempt to interview other people, including the defendant. The probation officer will write a report from all the information known as the pre-investigation report, or the PSR. The PSR will consider factors that influence how prison administrators classify the person and whether the person will become eligible to participate in programs that could lead to early release. The PSR includes the probation officer's sentencing recommendation based on all information and the U.S. sentencing guidelines. Before the sentencing hearing, the defendant and the prosecutor will review the PSR. If they disagree with the probation officer's recommendations, each side can file objections with the court. Now, that's just some preliminary information for defendants to consider pre-indictment, if they're on pretrial detention or if they're going through the journey. Now, for more information on matters to consider before sentencing, we really recommend that you look at some of the comprehensive articles on our website, and those include understanding plea agreements, loss amounts and sentencing guidelines, a sentencing guideline table, interviews with federal judges to prepare for lower sentences, 9 questions to consider before sentencing. There's just so much. And just at the bottom of the app, you'll see these links. And you can see that you could just, click on the links themselves and it will take you to the actual page. And then you can scroll down the page, get information, watch a separate video that we've created, and learn a lot more. This one happens to deal with loss amounts and the federal sentencing guidelines. It provides other links that take you to the table. So see, there's all types of interconnected articles that you can get for free right on the Prison Professor's website. And I do encourage you to get your more comprehensive information from prisonprofessors.com. Our app is just something where we publish regular content to keep people apprised of how the decisions they're making today have an influence on what opportunities open for them in the weeks, days, months, years, decades ahead. I made really bad decisions at the start of my journey. And just because I didn't understand the system, I had also an attorney who wasn't really spending time to get to know me as an individual or helping me understand the journey ahead. And as a result, I kind of went into this system blindly with unrealistic expectations. I went to trial. I made bad decisions during the trial. I committed perjury on the stand. I just failed in every way possible. And I want to help other people make better decisions. And that's why our team at Prison Professors produces so much content that's free, because we want to help people, at all justice impacted people. And that's why we publish an abundance of information so that you can start thinking about mitigation strategies and steps you can take today to sow seeds for a better outcome tomorrow. 100% open and transparent, and I'm here to help. Thank you, and wishing you the best on your successful journey. Oh, and one other thing. If you're watching this on the app, please do subscribe to the app. Subscribe to us on YouTube, on iTunes, or wherever you get your information. Prison Professor strives to be everywhere, soon to come on an Alexa app. We just want to help people understand the system so that they can prepare for better outcomes. If you have any questions, there's plenty of opportunities for you to leave comments, and I'll do my best to respond. But again, you can always visit us at prisonprofessors.com to get more information. Thank you.